we're going to have a little bit of interaction here because, as you see, we're talking about workforce and particularly about access to international talent. So I just want to have a look at the room and find out who here is a citizen from outside of Europe. Okay, 2 or 3. We're outside of Europe. Okay, that's good. We have some stuff for you here, even though we're talking about the EU. There are some implications for outside of Europe. Who here is a citizen of the UK? Hands up. And who is a citizen of the EU? Why are the UK people not putting their hands up? You still have 174 hours to go. We haven't left. Okay.
We're already out.
I haven't got a chair. Oh, I'm going to come down this end. You want to move down one? Move down one. Yep. Shuffle down. Okay, now we've done our little shuffle on the panel. Kate's introduced me, so let me introduce my panel. I'm going to start at the very far end. Jack Powell, you've already met in this session. Jack, Senior Policy Analyst at the BFI. Very glad to welcome Blanca Gray from the Home Office, who is the Policy Engagement Lead. Then we have Harry Prabhu, who is Policy and Events Officer at the Creative Industries Federation. And then finally, we have Victoria Burnip, who is a partner at Doyle Clayton and is a specialist in employment and business immigration law. You can't really talk about international talent without talking about what we do about homegrown skills. I'm not going to talk about it greatly in this panel, but I've learned in my interactions with politicians particularly, and with civil servants and officials, that it's really wise to put up front the commitment that our industry has to developing domestic homegrown talent. Because if we don't do that, that's the first objection that we find straight away from politicians. What are you doing about homegrown talent? We're doing an enormous amount. We're engaging with apprenticeships. We have programs in higher education, liaison with universities. We have the Next Gen Skills Academy, which is further education program for 16 to 18-year-olds as a level 3 qualification in animation, games, and visual effects. We're also engaging in the new T-levels. And we're doing lots of schools outreach through an organisation called Access VFX, which also includes animation. So, for instance, in the next few weeks, we're going to be at World Skills Live, where we'll be meeting something like 72,000 14 to 16-year-olds as they come through looking at their career options and telling them about the great career options that there are in this industry. So we're doing a huge amount. And if you do find yourself in that privileged position of having your 30 seconds with a minister, please do emphasise how much we are doing, because it's very important. Okay, so let's get back to international talent. And I'm going to... Where's the clicker? There we go. Let's have a look. I borrowed this one from the Home Office, and as you can see, they're still expecting Brexit on the 31st of October, on this slide at least anyway. And I think this actually just nicely compartmentalises what we're going to be talking about, because this session is going to be in a few parts. So we have, we're first of all going to be talking about the EU citizens who are already here, and what are the arrangements for them. The ones who are arriving before Brexit Day, if they're leaving it very late to get into the UK. Then we're going to talk about a period between Brexit Day, whenever that is. If it's 31st of October, it could be, or it could be the end of January. We're talking then about the period after that until the end of 2020, the transition or the implementation period. And then we'll talk about what happens after that. And we're also going to talk about what happens if UK citizens want to go out to Europe to work, either temporarily or to visit. So, and I will also cover what you need to do if you're taking equipment out to the EU. Right, so we're going to start with the current situation. The European citizens that are already in the UK, what do they have to do to be able to remain and live and work in the UK? Victoria.
Thank you. So I'm just going to grab the clicker.
your EU citizens, or anyone who is an EU citizen, if they haven't already, they should be applying for settled status or pre-settled status. Pretty sure everyone in this room will have heard a lot about this in the press. There's a few myths to dispel to start with. First of all, Irish citizens are unaffected, which is good news, but not everyone has realised that. And those who have permanent residence under the old EU law, which I think is what Genevieve was talking about in the context of her colleague, the horrible 60-pager with all of your ins and outs and travel dates, that is being replaced by the pre-settled status or settled status scheme. So if you have that, you still need to reapply. You need to apply all over again, but thankfully it's not a 60-page document, and I'll take you through what the process is. So EU nationals, actually before I even get into it, there's a couple of kind of things that were taken as read here, that this is the situation in a no deal. It might be slightly different in a deal, might be more beneficial. And I've just presumed for the purposes of this that we are leaving on Halloween because it just makes it easier. But obviously that could shift. So anyone who is an EU national or a family member who has their bum in the country by 11 p.m. on Halloween, the day we leave the EU, can apply for pre-settled status or settled status. And they have until that transition period that Neil referred to, 31st December 2020, in order to apply. So pre-settled status is for anyone who has been in the UK as a resident for less than 5 years at the date of application. If you have pre-settled status, you will then need to get settled status when you hit 5 years. If you've been here 5 years or more at the date of your application, you're eligible for settled status. And that's the new terminology we're now using for permanent residence. That was the old language. And it's equivalent to indefinite leave to remain for non-EU nationals, and in fact a bit more generous in that you can leave the UK for a longer period of time, 5 years rather than 2, without losing your status. So, what does residence mean? It means you need to have been here at least 6 months in any 12-month period. And barring a couple of compulsory military service exemptions, you are allowed one block of 12 months out of any of those 5 years for what's called an important reason. So that can be study, childbirth, serious illness, training, or an overseas work posting. So how do you actually go about doing it? Happy days, the iPhone 8 has come online with the scanning process this week. It used to be you had to have an Android phone in order to do the first stage, which is the ID check. So anyone with a document that has that little logo on it, which looks like an equals sign with a blob in the middle, that if that's on your passport or your residence paperwork, you can download the app on the iPhone or the Android, provided it's an iPhone 8 or more, and you can scan your passport, upload a selfie, and that's the first stage of it done. You can then move to any desktop or laptop or any device and carry on with the next stage, which is the residency check. So this is where we used to have clocking in and out of the country for the last 5 years. You needed to prove income, you needed to prove under the old regime that you had comprehensive sickness insurance if you were a student. All that has happily gone out of the window. You input your national insurance number, hopefully you've got one. If you do, input your national insurance number and it will tell you whether or not it believes you are eligible for pre-settled or settled status. Or if, like some of our clients, you've forgotten your national insurance number, then you need to move to the next stage, which is to upload some residency paperwork to demonstrate you've been here. So happily, again, the focus used to be on income, now it's on residence in the UK. You can upload up to 10 documents, so you need to be selective about what you use, and you should check the spelling of names across your paperwork if you've been married or you've had a divorce. So what you want to do is you want to hit the whole 5 years, if you're eligible for settled status or more, in 10 documents. You want to include things like bank statements, annual bank statements, council tax documents, tenancy or mortgage documents, because if you only upload a document one date, it was only good for that month. So you need to check your documentation carefully. Third stage, happily I haven't had any issues with this in our clients, there is a criminality check. So you need to disclose overseas and UK criminal convictions, but you don't need to disclose that speeding fine or that speed awareness course you went on, spent convictions or cautions, and then they will do a check against our databases. If you've been convicted of what they deem to be a minor crime, you should be okay. You should still get pre-settled or settled status. So where are we at the moment? The expected processing times was 1 to 4 days. That was in the good old days of March 2019. I once had a record application in 2 hours. Now it's looking at least 2 weeks. And as we gain momentum like a snowball up to Halloween or beyond, the processing time is likely to take even longer. So if you are successful through this 3-stage process, the Home Office will email you. You are then given a link to click through, and it will give you that lovely selfie you uploaded at the ID stage, and it will demonstrate that you hold either pre-settled or settled status. So what do I recommend you do for colleagues, friends, employees? Apply for it as soon as possible. Do not wait until the last minute. There's no reason why you would. So if you haven't already applied, or you know someone who hasn't already applied, like a number of my colleagues, I'm trying to push them towards getting it done. If you have anyone who's planning to come in to the UK after Brexit, try and get them in before Brexit. If they're in before 11 PM, in theory they can apply for pre-settled status. If you have to travel overseas and come back to the UK after we leave the EU, and you haven't applied yet, then how will they know whether or not you were here pre or post Brexit? I would recommend you carry some residence paperwork, evidence of your residence, just to facilitate a quick entry into the UK. And then there's been a big issue about supporting the workforce and what can you actually do to encourage the workers that you have to go through this process. I think make sure that there's time in the day to actually let them go through the application process, and make sure there's a device, whether it's an iPhone 8 or an Android, to actually enable them. Put it in a room. Some of our clients have been doing that. Communication is really key as well. Dispel some of the myths. A lot of our clients' workforce have been saying, well, I've already got permanent residence, I don't need to do it. It's not true, you do. Well, it might override or give me British citizenship and override my EU nationality. That's not correct. It's simply permanent residence, but it does not change your nationality. And I think critically, it's telling people what you do know and also what you don't know. It's almost as reassuring sometimes to be able to say, well, we do not know X, Y, Z, but we will come back to you when we do. And give some positive reasons for applying. I don't want to touch on the other panelists too much, but in due course, there could be it could be facilitating a move to a new employer. It could be just the simple case of, well, you want to get back into the UK a bit more quickly, and if you can demonstrate you've got pre-settled status, you might cut down that queue in half when you come back through customs. So try and encourage people, because a lot of people are saying, well, why would it even bother? Right to work checks don't change until 2020. Give them a reason. So that's where we are.
So you mentioned citizenship, and
yes.
It's definitely not citizenship.
Definitely not.
But what does it confer? What rights does it confer?
So it confers the right to permanently live and work in the UK, and it also can confer some rights on your family members who are not EU nationals, so it could be equally as important. And it confers the right to use the NHS and all the rest of it, and you can stay in the UK for as long as you want for the rest of your life. And you can leave the UK and move abroad for up to 5 years, and you can still retain your settled status. So it's a really simple process now, and I don't see really why anyone wouldn't apply for it.
And there's no cost?
There's no cost at all now. So indefinite leave to remain, by comparison, for non-EU nationals is about £1,500 at least. Citizenship as well, very, very expensive. This is now free of charge, as long as you can use the ID check-in within the app. If you do need to go along to a centre and have your documents actually scanned in, there could be a small charge for that.
And it's a very high chance of success.
Yes, it is, because even if you had a less than clear-cut employment status, so you haven't worked for the full 5 years, and your national insurance number is not necessarily bringing up all of your records, or you've been studying, or you've had time off for family, you can supplement that with your documents and show that you've been resident here, and bank statements are really important in that. So we've done a lot of applications for retired individuals who are not earning money, and they've all had successful applications.
And can you appeal if you don't get the decision you expect?
You can apply for administrative review, and there's a fee of £80 for that, so you might just be better off reapplying for free.
Okay, right. So, as employers, why do we want our European workforce to stay, apart from the fact that they're extremely talented, of course? But why do we really want to encourage them? When we get to talk about the future immigration system, which we'll do a little later in the session, you'll see that there is a cost in getting a visa, and there are other ancillary costs involved in that. So as employers, there is a potentially quite a large hit on your payroll and on your recruitment costs. So anyone who's got European pre-settled or settled status will be at a significant advantage in the labour market. So that's another good reason to let them know. Okay, so that's what we do if they're already here. So let's move on to that second window. And here, deal or no deal starts to rear its head. So obviously, if there's a deal, the settlement scheme continues. Well, it continues in either case, doesn't it?
It
but
does,
the application window continues.
Yes, but for another 6 months.
So you could come in after October the 31st, if that is indeed Brexit Day, and still apply for settlement.
As long as that's still the case with whatever amendments are put through on the deal, yeah. But as we understand it, yes.
Right, okay. But if we're in a no-deal scenario, is that the point at which free movement of people effectively ends?
There is a transition period, as you say. So anyone who's in, and again, I'm going to assume Halloween, shorthand for 31st October, is the date we leave. The ease with which you can remain kind of diminishes from that point onwards, and then we are into the land of European temporary leave to remain.
I was going to ask Jack about European temporary leave to remain, because that was quite contentious, and there has been some confusion about whether on November the 1st, in a no-deal scenario, somebody can come in and work immediately.
Yeah, there has been some confusion around this idea of temporary leave to remain, not least because a very similar policy has been announced on multiple occasions with amendments, and so there's kind of a bit of confusion about which one applies. But yeah, to kind of take over from Victoria, in a no-deal scenario, EEA citizens that come to the UK are subject to what will be known as rules around European temporary leave to remain. The government has said that in a no-deal scenario, after October 31st, freedom of movement in its current form will end. What this means in practice is that it means that use of European ID cards to come into the country will slowly be phased out. It'll mean that there are slightly different security checks on EEA citizens coming here. But in the period between a no-deal exit and the end of 2020, basically, EEA citizens will enjoy the same rights to come to the UK and to take a job or to study or to work as they do currently. The change comes at the end of 2020. If you want to stay after that period as an EEA citizen, you'll have to sign up for this temporary leave to remain, which would give you the right to stay here for 3 further years. What happens after 2021? Well, this is when the government has said that it will introduce its new immigration system. We'll go into that in more detail shortly. But following 2021, basically, it's believed at this point that EEA citizens and non-EEA citizens will be treated the same by this immigration system, whatever it looks like. So yeah, basically, in a no-deal scenario, if you're an EEA citizen coming here after, say, October 31st, again, for ease of reference, you're fine up until the end of 2020, which is when you have to apply for this temporary leave to remain. The reason that there has been some confusion is because when Theresa May was Prime Minister, a very similar policy was announced, which required EEA citizens to apply for temporary leave to remain after they'd been in the UK for 3 months. That is no longer the case. As I say, you apply for it you can apply for it at the end of 2020. The other reason for confusion was, as I'm sure many of you saw in September, Priti Patel, the Home Secretary, made a statement that said that freedom of movement would just end after a no-deal Brexit. That has been tempered into this statement on freedom of movement in its current form, which operates as I've just explained.
And this European TLR to get the vernacular. How do you apply for it? What's it cost?
I would actually point to Blanca on this one.
Okay.
Yeah.
I'll come in on that one. The European temporary leave to remain obviously will become operational on the 1st of November, should we leave without a deal. And it will be quite similar in the terms of how you apply the application process. It will be online as well, similar to the to the EU settlement scheme process. It is free, so it will be free, and that's how it will work. So basically, it's only for those, as Jack said, it's only for those individuals who come after 31st of October and want to stay after December 2020. And obviously the deadline will be December 2020 to get that permit, and it will give them 36 months, 3 years longer, which obviously will link in to the new immigration system, which is envisaged to start to take place, to kick in January 2021.
So this is not employer-sponsored. Anybody can come and claim this European temporary leave to remain. Yeah.
Mm-hmm.
So what's the risk then? Because clearly, you would think that everybody's going to wait until the last possible minute and extend their 3 years as far into the future as they possibly can. Will the visa system be able to cope with having all those applications in the last minute?
Well, the good thing, and I will come in a little bit here with some statistics about the application numbers that we have already received through the EU settlement scheme. I mean, the Home Office is obviously used to handle a high number of applications. We've already received over 2 million applications since we opened the scheme in March 29th. So obviously, what we'll say, and as soon as this becomes operational and the 1st of November comes in and we have left without a deal and the system switches on, obviously the communication campaign will immediately start to promote the scheme in the similar way as what we've done with the EU settlement scheme, so that the applications sort of get staggered and there is a higher chance of going through a smooth application process. So, but obviously it's only for those who wish to stay longer than December 2020. If somebody comes in for just 10 months during that implementation period, they do not have to.
It's free movement as we currently know it, essentially.
But there is an encouragement to apply early, because you can get some of that time to count towards any future indefinite leave to remain application.
So it's effectively recorded by the fact you've got that visa.
Yeah, exactly.
Right.
So that would be a benefit, I think, to staggering the applications.
And also, you're always at the mercy of policy change. Those of us who remember another visa called Tier 1 General, which was like a freelance entrepreneur visa, was widely abused and was withdrawn with 2 days' notice. So you were always at that risk of policy change. Just going to take a little detour now here and bring in Harry, because one of the things that we've seen in the difference between Theresa May's deal and Boris Johnson's deal that he's brought to Parliament is, and Jeremy Corbyn has been on Boris's case quite heavily on this, as the workers' rights issue. So what's changed? Why has Jeremy suddenly got a bit exercised about this?
So with leaving the EU, it's actually two parts. So I guess everyone hopes it would just be one thing and we'd be out of the, as in terms of ending the uncertainty. But you have the withdrawal agreement, so things such as Irish border, citizens' rights, as we discussed, and payments to the EU. And then we have this transition period in the event of a deal where we start discussing what our future relationship post-divorce will actually look like. So for that, we have a political declaration, which is a non-legally binding document in which we try and set out what are the kind of things we want to continue to cooperate with the EU on. And so previously in the withdrawal agreement, so the part that was legally binding, there were these protections in there for employers' rights, things such as maximum time you can work in a week, rules against non-discrimination, and all of that was secure going into the future. And now that's been moved into the political declaration, it's more up for debate, for negotiation than it was previously. That's not to say anything will immediately change this. So even in the event of a no deal within the withdrawal agreement, there's provisions for all of EU law as it currently is to be transferred into UK law. So we don't want to have a cliff edge where suddenly, because quite a bit of our law is based on EU directives, we want that to transfer over. But then what happens next, I guess, is up to Parliament or the government or whoever's really in power to see to see what they can make of that, and that depends on an election in a sense. Who do you vote for? What are their policies? Because then, post leaving the EU, they will then have the power to amend these laws on discrimination if they choose to. I mean, maybe they won't. Maybe they'll think, this would be so beyond the pale in terms of public policy, why would they do that? But they would have the option there, which currently they don't because of EU law enforcing those rights. The part that some people are a bit more scared of are statutory instruments, otherwise known as Henry VIII clauses, because of the way Henry VIII operated with declarations. And
it's our modern democracy.
Going back 600 years. And those are sort of clauses of secondary legislation to allow small changes to be made. So say, for example, you want to close down a particular road to do roadworks. You don't want to have to put a whole bill through Parliament just for the sake of doing that. You want to make quick action as a minister. So use a statutory instrument or a Henry VIII clause to get it done within 30 days unless Parliament objects. And so we have these within the withdrawal agreement to make small changes. So if we have an EU agency currently in charge of something and we want a UK agency to take over that post leaving the EU, then we can put a quick name change into the relevant law and that's done. Now people are worried though that with their ministers having this power to make minor changes, what if they overstretch that? What if they suddenly say, well, instead of just saying it will be the UK Atomic Agency or whatever, instead of the EU Atomic Agency, we'll have a wholesale change to discrimination policy within the workplace, or paid holiday, or maximum hours you can work in a week, which would probably be subject to legal challenge and parliamentary challenge, but there is that risk there.
Blanca, do you want to comment on that?
Yeah, of course. Obviously, in terms of the new immigration system, we are currently, the Home Office is currently looking at some options. I mean, at the moment, we are not really, we cannot really talk about what is going to entail, what sort of routes are going to be in place, because at the moment, the Migration Advisory Committee is currently looking at the option of a points-based system and how that option would work in the UK. But obviously, we are expecting the work to come back to the Home Office sometime in January. So then once we get the recommendations back from the Migration Advisory Committee, then we'll be able to resume, if you like, the engagement with the key stakeholders, mainly with employers, to see, what sort of options we can implement and how, and to get feedback mainly, to get feedback particularly from businesses in terms of the different recommendations and options that will be presented by the MAC.
So shall we just sort of wind back on the timeline on that? Because there was an immigration white paper published in December, I think it was December the 18th last year. Mm-hmm. And we were already in the middle of one MAC consultation on the shortage occupation list. Yeah. So publishing a white paper at that point certainly spoiled my Christmas. But how much of that white paper do you think will get carried forward? Because there are a number of things in that. Perhaps before we ask that question, maybe Jack, could you just run us through some of the things that were in the white paper?
In the initial white paper?
Yes.
Yeah, absolutely. So as Neil said, this is a white paper that was released by the May government in December 2018. Some of the things that it included was the continuation of a £30,000 salary cap for people coming in on a Tier 2 visa. So that's people that are coming in.
So this is the skilled worker visa?
Yeah, exactly. So, worker visa, kind of permanent employment. that was what was written in it when it was released, but it was pretty quickly reneged upon due to I think quite a lot of backlash, and it became
it was quite a split in cabinet, I believe.
Yeah, absolutely. And instead, the government said, okay, well, we'll consult people over the year on this and what it should be set at. I know that one of the points that Neil in his work, Harry in his, and in my own from BFI, one of the points we kind of continually make is the issue with the £30,000 salary cap for people in jobs in the creative industries, given levels of pay compared to their levels of productivity of workers, and the highly specialised nature of work in the sector. This is a case we continue to make. So that was kind of initially put out there. Another point to pick up on the kind of initial paper is around Tier 5 visas, which is what you use for temporary workers coming in on a short-term basis. So if you've got freelancers joining a production from outside the EU, that's the kind of visa that you would use to help them join. So yeah, that's a bit of an outline of what was in the.
I mean, there were some things in the original white paper that we quite liked.
Yeah.
I'm thinking like the fact that there would be no quotas, because just to put one fact that we haven't laid out there is it's one visa system for European and non-European migrants, the same visa system. So for the first time that European migration is brought within the net of the visa system, and therefore there will be some cost. I'm just going to give you some figures that we worked out. I've got some quite good data on the visual effects and animation workforces combined. They're very similar skill sets, so we take them as one. About 7% of the combined workforce of animation and visual effects currently is on a salary below 30,000, and they're from Europe. 7% from Europe and below 30,000. So those they're already here, so they don't need a visa. Yeah. But of course, we have migration, we have a churn of staff all the time because of the temporary and project-based nature of our work. So that will start to cost us money when it happens, because if you have a worker who, well, say you want to employ an animator on a job, probably a junior animator of somewhere around 26,000, something like that, they would have to be paid £30,000 if they were from Europe. To get that visa. That means they're sitting alongside a British animator, maybe with a year or two's more experience. They are not going to be happy with 26,000 any longer. They're going to want 30,000 as well. So it becomes a de facto minimum wage in that industry if you're going to mix European and UK workers in the same job role. And the overall impact of that is quite substantial. We reckon about £18 million on the collective industry payroll. So it is quite a hit for us, and therefore, not surprisingly, we did actually campaign quite heavily against it. But we've now had a Queen's speech, and as you say, the points-based system has been proposed. So, Harry, do you want to talk about what the advantages of that might be for us if that were to come about?
So as Neil was saying, with the issues around minimum salary payments in order to get permanent workers into the UK and the problems that will cause for EA talent working in the creative industries, those issues are less significant within a points-based system depending on how we structure it. So with a points-based system, we're looking at qualities outside of salary. So maybe someone's work experience, their qualifications, their language or technological skills, and the government would put a weighting on those, and you'd have to cross a minimum points threshold in order to qualify. So you wouldn't necessarily need an employer sponsor, you wouldn't need to meet a particular salary, and so that's all positive. However, I guess the question for us is, how do we really make this work for the creative industries? Yeah, because work experience, it's quite a broad term, so it's qualifications, and for the performing arts or a lot of creative productions, it's a quite niche thing, right? It's not something a Home Office official, not something that anyone can necessarily appreciate. You need people with expertise in their subsector who understand what it means to be a talented musician, a talented actor, a talented animator, and those are very precise qualities and skills where it takes time to evaluate. Many people go through months-long application processes or audition processes.
This is in the Australian system. I mean, it's up to about 21 months for some of those visas, which would be quite detrimental, I think, for most employers. They wouldn't be able. We need to be very agile businesses.
They don't like 3 months.
3
They run
months.
like 21 months.
Yeah.
So it's key, I guess, therefore, that we try and make sure that if there is some kind of points-based system being put in, that we ensure that it is able to take account of these more wider, diverse qualities within the creative industries and isn't just the generic system applied to every other industry. Because I don't think we can compare the creative industries with finance. I think we're much more exciting
We're not as well paid.
And so, that's what we're calling for at the moment. So with the Migration Advisory Committee consulting on this, we want there to be, regardless of what is the salary threshold position, and it definitely needs to come down, there needs to be alternatives. So where someone doesn't meet a particular salary threshold, perhaps because they are in a junior role, but they are the future of a profession, there should be a way of evaluating the talent and saying this person has a lot of potential, they've got they can contribute to the UK, and therefore they should have another route by which they could come in. Now, whether that's a points-based system or through representative bodies, having a say in saying, well, in our subsector this person has a lot of valuable skills, and therefore endorsing their visa in the same manner the Arts Council England do for Tier 1 exceptional talent visas. As if there's some other means like either of those two or any other alternative, we think that will massively help mitigate the effects on EA talent coming to the UK post-Brexit.
So there's a consultation going on which you mentioned. How do you reply to that consultation? And when does it close?
Yes, of course. Okay, so there was, based on the white paper that was published on the 18th of December, so there was a whole, well, in the end, it came up to about 10 months of engagement with the key stakeholders, mainly with businesses. And obviously, the salary threshold of 30,000 was heavily criticized, and there is other elements of the white paper. But of course, that period of engagement mainly with businesses through different sectors, it gave us a lot of insights, gave us a lot of information, a lot of insight, a lot of feedback for every of these elements. So obviously now we have paused that engagement, if you like, whilst the Migration Advisory Committee is looking at this points-based system and how would it work with the UK. And obviously we are hoping to resume that period of engagement very soon.
But
Not yet.
the current consultation, I think, closes on, is it the 4th of November, 5th of November, something like that?
The 5th, isn't it?
5th. Mm-hmm. Easy date to remember. We haven't mentioned the shortage occupation list, and I know I certainly did quite a lot of work on it, so did the Fed, and we have had some changes recently, haven't we, on the shortage occupation list. Victoria, do you want to just mention those?
They've been for the power of good, really, although not necessarily for your industry in particular.
Well, I think they're quite good for us.
But they're even better for tech and IT. So the stats were that previously 1% of all UK jobs were on the shortage occupation list, and apparently that's now gone up to 10%. So whereas previously there were fewer jobs, and then so when you're getting a visa for someone, you have to match the job description to a code, and if the code is on the shortage occupation list, then depending on whether or not you meet the criteria, you don't need to pit non-EU nationals against UK nationals and give priority to UK nationals, so you don't need to advertise the job. So it's a really nice way for employers to bring talent in.
Of course, the immigration white paper abolished the resident labour market test,
Yes.
so we've lost that advantage. It also didn't link anything to the shortage occupation list,
No.
so we've lost that advantage.
Yeah.
Even though now we have
So it's a short-term
animators,
advantage.
graphic designers, arts officers, producers, directors, they're all on the shortage occupation list.
And they've all been widened down predominantly to any
role within that
category instead of being within a bucket. But yes, the future is now uncertain because the benefits of the shortage occupation list, as we currently enjoy them, will potentially not apply.
So that's one of the things we probably need to fit into the points-based system, or any system for that matter, and also to reduce the actual cost of the visas. But we're getting into policy now, so we need to kind of move on to the other bit about what do we do if we go abroad as UK citizens. And if you can click on the slide for the next one. I borrowed this from the Home Office, hope you don't mind. bit of a quiz here. Who knows what a country in the Schengen zone is? Can anyone name me any of the 6 countries that are in the EU but are not in the Schengen zone? Yeah, I see you're all so well informed. Denmark. No? Wrong. Switzerland. Yes. So, well, Switzerland is actually in Schengen, but not because it's a EU country. So I think you probably need to work this out quite quickly and understand what is the Schengen zone, because it is. There are 26 countries. It's all but 6 of the EU countries, plus Iceland, Norway, Switzerland, Liechtenstein, who are all EFTA members. It also includes Monaco, San Marino, and Vatican City. It also includes the Canary Islands and Madeira and the Azores. But it doesn't include Romania, Bulgaria, Croatia, and Cyprus, which are all EU countries. And crucially, it doesn't include Ireland and the UK. So that's the Schengen zone, and that has a bearing on whether you will need a visa or a permit in future. You've got to work out, are you going to a Schengen area country? And if you are, then what will decide whether you need a visa or not? You need to check the Schengen border code. Go and Google it, you'll find it there. If it's a non-Schengen state, then it reverts down to the member state's policy, not to the Schengen policy. If you're going for less than 90 days in 180 days, you will need to see the member state policy, but you probably will not need a visa for that. That seems to be okay. Be careful here, because this applies both to business and to personal travel. So if you do a 3-month contract out in Europe, in Germany, and you come back to the UK and think, phew, I need a holiday, I'm just going to lie on the beach in Lanzarote for 2 weeks, well, that's in the Schengen area, so you're outside your 90 days in 180. So you may need a visa at that point just to go and laze on the beach. But in general, as a visitor, you will not need a visa. So it is fairly light touch, but just be careful and go and check the various websites. It's worth doing. The short tourist visits, you'll be fine most of the time. And of course, Ireland, no problem. The common travel area will still exist. You won't be able to use the EU lane at the border. You're going to have to go into the everybody else queue. And take care with your data roaming. But even though we've got a nice agreement currently, that may not continue in future if we're in a no-deal scenario. And also be careful if you're driving. If you're going to take your car, you may need to get a green card. You certainly need a GB sticker. And you may need an international driving permit. Check on which country you're going to. You'll need 6 months left on your passport as well, and your European health insurance card, the EHIC, may not give you what you need in Europe if there's a no-deal scenario. What do you do if you're taking kit? Well, you will need to do carnets, most likely if we're in a no-deal scenario. Anyone remember ATA carnets? You'll be doing those already for the rest of the world, but you will maybe have to do them for Europe if we're in a no-deal scenario. They cost about £200 to £500. You get them through the Chamber of Commerce. It's cheaper if you're a member of the Chamber of Commerce. And obviously that will slow you down at the border because you're going to have to present those. So there are frictions there, unfortunately. They are the best way of taking out kit, and it also makes sure that you can get that kit back into the UK if we're in a no-deal scenario, because otherwise the customs officers may think you're importing your own kit back into the UK, and you don't want to be paying the VAT and duty on your own kit again. So there are quite a few things to think about if you are going out to the EU. We've gone through a heck of a lot there, and I haven't gone to questions. Does anyone have any questions on any of those pieces of information that we've just given you, or anything that we haven't covered that you're worried about? If we can get the microphone over here, and just say who you are and where you're from.
Hello, Genevieve Dexter from Serious Lunch. Just right at the beginning, Victoria, you were saying that even though my employees have applied for settled status and have received that certificate, they're still going to have to go through another process, or if
that was permanent residence. So if I don't know the ins and outs of what you described, but it sounded like the old permanent residence route under EU law. So we've always had the right at the 5-year point to demonstrate your permanent residence under the EU law, but it was a much more document-tastic application. If you have that, you still need to apply for settled status. You need to effectively convert your permanent residence into settled status.
But if she's got settled status, does she?
She's got settled status on the new regime. That's fine.
When did the new regime come in?
Sorry?
When did the new regime come in?
It opened up in March 2019.
Okay, so I think she's okay.
Okay. If you're not sure, you can send it to me and I'll have a look for you.
Thank you.
The front here.
Just to show how quick moving things are, I think the Prime Minister has just said that he will support an extension if the House supports an election in December.
Wow, hot off the press. If you're watching on catch-up...
Don't phone this number.
Yeah. Okay, anyone else got any more questions? No? Okay.
Sorry, just another last slide. Could I just add an extra point?
Oh, of course, Tier 4. We haven't talked about Tier 4.
I didn't mention... Sorry, just on the last slide on the temporary movement, though, before Tier 4. So on the kind of activities that are permitted, I just wanted to add that that's not paid activities. And so that's a big issue, really. So you can do business activities in terms of interviews, meetings, and auditions. But in terms of doing a performance or something you'll get paid for in a European member state, that will be 27 different regulations, unfortunately, as far as we know, in terms of the visas for applying for that. So the 180 days for tourist and visitor visas. And so we're trying very hard to, we're trying to encourage the government to try very hard to negotiate something with the EU on touring visas to enable UK talent to go and perform and work still in EU countries in the event of a no deal. But nothing has happened so far, so it's quite concerning.
So I just mentioned Tier 4.
Tier 4, yeah.
Very quickly, because we're running out of time.
Sure. So on Tier 4 as well, so something positive that's come out. So Tier 4 are international student visas. And so the good news that has come is that if you start a course from next year as an international student, at the end of your degree, you'll have 2 years in which you can stay in the UK and take on work outside of employer sponsorship. And so this is a reversion to the previous scheme before Theresa May came into power as Home Secretary and put in a harsher policy there. And so hopefully this will encourage more international talent to come to the UK and slightly mitigate the impact of Brexit. I know the Home Office have been marketing this strongly to future partners in India and China, and hopefully will encourage more international talent to come to the UK and work in the creative industries.
Okay, right, I'm going to wind it up there and say thanks to the panel, to Jack and Blanca and Harry and Victoria. Thank you very much. If you could show your appreciation, please. Last few notices. We're very, very keen to get these forms in. Otherwise, we're going to be financially embarrassed on this because BEIS, the Business in Energy and Industrial Strategy Department, needs that for their reporting. So please, could you do that? And find somebody to hand them to if you filled it in. Don't take it home with you. Thanks to all the speakers and the various organisations who've helped throughout the day, and to Kate Bulkley for her questioning. Thanks to the funders, BEIS and the Business Readiness Fund. Thanks to Tim Patterson and to Greg for producing the sessions, and to the CMC for organising the event in collaboration with Animation UK. My colleague Kate O'Connor couldn't be with us today, but thanks to her for also liaising with BEIS over this. And thanks to my team at UK Screen Alliance as well. More CMC events are available. Here's the commercial. And the next one being Manimation in Salford on the 11th of November on the business of animation. And please do register for that and go along. There'll be plenty of good sessions there, I am sure. And it may not be the last word on Brexit that you hear today. There is some tea and coffee. I'm very sorry we've overrun slightly, but there's some tea and coffee outside. And thank you very much to you, the audience, for coming along. Thank you. Goodbye.